Good evening and welcome to the Thursday, March 27th, 2014 meeting of the Planning and Zoning Commission of Indian River County. The first item on our agenda is the call to order and the Pledge of Allegiance. Maria, would you please lead us in the pledge this evening?
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Item number 2 on our agenda this evening is the approval of minutes from the February 27th, 2014 meeting. Do I have a motion?
Motion to approve.
Second. Did you get that, Jordan and Charles? Did you get it? All in favor?
Aye.
Aye. Any opposed? None. Item number 3. This is an item that's not on consent. It's Diamond Court West. It's a request for a major site plan and preliminary plat approval for a 53-unit single-family residential development. This is quasi-judicial, so I believe I'll have to ask all the members of the commission if there has been any ex parte communication regarding this that would render you incapable of making a fair and balanced judgment on this case.
Correct.
If there are any such ex parte communications, please speak up now. I will disclose that I spoke with Stan Bowling about this today, but I assure you I'm fully capable of rendering a careful, deliberate decision on this. And with that, oh, I'm sorry. Oh, we need to swear everybody in. Right. That's right. Everyone who plans on speaking this evening, please stand and be sworn in.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Take it away, fellas.
Good evening, Chairman Zimmerman, members of the Commission. For the record, I'm Ryan Sweeney, Senior Planner with the Indian River County Planning Division. Tonight we have a 53-unit single-family residential development to be known as Diamond Court West. The subject site had a previous approval for a 70-unit multifamily project under the same name. However, no construction commenced, and that approval has since expired. The subject site is located at the northwest corner of Indian River Boulevard and 41st Street and is zoned RM6, residential multiple family up to 6 units per acre. The property to the north is a multifamily residential project known as Laguna Vero Beach, and the property to the west is a single family residential project known as Casabella. In looking at the aerial, you can see the site, not very clearly, but you can make it out that the site is a former citrus grove and contains no protected or specimen trees now. The plan proposes a total of 53 units with a recreation tract located around the stormwater management area, which is both of those are located to the east of the residential development. The site plan also depicts the individual lot lines that will be created via the plat over the site plan process. Through this process, each individual unit, together with the immediately abutting property, can later be sold off fee simple as individual parcels. The proposed layout includes an internal loop road with sidewalks on both sides and a two-way gated entrance on 41st Street. Required improvements for the proposed project include internal and external sidewalks, street lights, street trees between the internal loop road and the internal sidewalks, and a common green space area set aside. The external sidewalks will be provided along the site's frontage on both Indian River Boulevard and 41st Street as depicted here in dark blue. These sidewalks will be required to be installed prior to issuance of the first CO for the project. Additionally, the common area internal sidewalks, which are depicted in red, will also be provided prior to the issuance of the first CO of the project. The remaining internal sidewalks depicted in green will be provided on a unit-by-unit basis and will be a condition of issuance, condition of approval for each individual CO for each respective unit. A street lighting plan is currently being coordinated between the applicant and the City of Vero Beach, and will need to be approved by planning staff prior to site plan release and is a recommended condition of approval. The site plan and preliminary plat also depict a 1.63 acre common green space set-aside tract provided around and upland of the proposed stormwater management area. That tract is approximately 10.1% of the site and exceeds the 7.5% requirement. A Type B buffer with a 6-foot opaque feature is required and provided along the site's frontage on both Indian River Boulevard and 41st Street. The 6-foot opaque feature will be provided in the form of a 6-foot tall block wall with the required landscape materials provided on the outside of the wall. Additionally, one street tree will be provided every 50 feet between the internal loop road and internal sidewalks on both sides. And lastly, there will be a littoral zone planting provided on the periphery of the stormwater management area. Therefore, staff is recommending that the Planning and Zoning Commission grant major site plan and preliminary plat approval with the conditions as outlined in the staff report. Thank you.
Thank you. Well done. Would a representative of the applicant care to add anything at this time? Would you just state your name and address?
Good evening, Steve Moeller, Masteller Moeller for the record. I don't have a presentation tonight. Ryan did a good job explaining. The project's pretty simple. So unless there's any questions, I'd look forward to your positive vote.
Any questions for? Thank you.
Okay, thank you.
Anything unusual about this? This seems pro forma. I mean, were there any unusual site conditions or anything that needed to be addressed, or is this just a straightforward? Everything worked out well according to plan?
It did. It was straightforward. It had been approved for development before, and this was a slight variation.
Any questions that any commissioners have about this application? Do I have a motion?
Motion to approve. Staff recommendations.
Second. Todd, and did Jonathan, was it you and Jonathan second? All in favor, say aye. Aye. Any opposed? Motion passes unanimously. Thank you. Item number 4 on our agenda this evening is a legislative public hearing. It's the consideration of amendment for land development regulations, section 973.04, section blah, blah, blah. It's a nuisance abatement special assessment, and that's what we're here to discuss. If this requires anyone who wants to speak to also be sworn in, is that correct, since it's a public hearing?
No.
No? Okay, wonderful. All right. And I understand the county attorney's going to give us a presentation this evening. Is that correct?
Good evening, Chair. Yes, it is, sir.
Take it away.
To the Chair and to the full Commission, thank you very much. My name is Dylan Reingold. I am the county attorney. A couple months ago, one of the commissioners and I were sitting down talking, and the issue came up as to, how could we do a better job of recovering our costs from doing nuisance abatement and demolitions and the like. And essentially, that discussion led to the drafting of the ordinance that's been presented to you tonight. Under our existing code, we do have a process for nuisance abatement. Essentially what happens is a code enforcement officer can go out, they can issue a notice to appear, the individual then would have a hearing before the code enforcement board, and then the board could essentially rule or determine that that the county can go out and abate whatever nuisance is found on that property. Now, one of two factors needs to be determined in that decision, and one is whether there's a threat to the health, safety, and welfare, and then the second item would be is whether there was irreversible and irreparable harm. And essentially, if the costs of such assessment aren't paid by the landowner, then essentially the county can go out and put a lien on the property. Similar process for demolitions. Except it's through the building official instead of through the code board. And the building official can go out and determine that essentially a piece of property or a structure on a property is just in such disrepair that there's no hope in saving it, no hope in improving it, and that it really is a threat. And therefore, they will issue a notice for the property owner to demolish the property. If the property owner fails to comply, they would seek board approval for the county to go out, have the structure demolished, and such as like the nuisance abatement, then if the costs are not paid for, then a lien would go on the property. Now, there are limits to the county's ability to collect on these types of liens. First off, you can't foreclose on a lien that's on a homestead property. Second, oftentimes has happened, certainly in the down economy, a lot of our liens have been wiped out through a lot of foreclosure actions. So what does this bill do? Well, this bill adds sort of a new tool to the toolbox, and it would allow the county to be able to put these types of assessments for these liens onto the tax roll. And this would essentially provide our ability to do a better job of collecting and also be able to collect sooner. It gives a big incentive to the property owner for them to have to pay off an assessment that's put on the tax roll by March 31st, which is coming up in a couple days. And the penalty for that essentially would no longer be, oh, I'll just sit and wait till I go to closing, but essentially if they don't pay, then their taxes are delinquent. They could go to a tax certificate, could be sold, tax deed application process. So there's certainly ramifications to the property owner if they did not pay. Now, this is not a novel approach. In 2007, Polk County adopted a similar approach, and other nearby counties, Palm Beach County and St. Lucie County, adopted a similar ordinance in 2012. First off, I would like to say that there was, in working with the Community Development Department staff, which has been absolutely wonderful through this entire process, I did draft an amendment that is sitting before you, and essentially that amendment would direct the staff, the building official, and the community development staff the code enforcement staff who works for the code board, to present essentially a list of properties to the Board of County Commissioners by October 1st every year. That's an improvement. I think it's an improvement as recommended from staff over what had been originally drafted, which was essentially after 90 days after the lien or after the notice of the assessment, bring an item to the board. So you would essentially have these continuing little items keep coming forward. Instead, now under this process, you would have one time a year. It'd be a one-time shot where staff would essentially present a list to the Board of County Commissioners, say, here are all the delinquent properties we want you to consider. And by October 1st is important because if you were to take advantage of this tax roll assessment process, we would have to let the tax collector and the property appraiser know that we were undertaking this by January 1st. And that the statute requires that notices be placed in the newspaper 4 consecutive weeks before a public hearing. So by having it October 1st all at once, it gives the board to consider which properties, if any, were to be added. That would then give sufficient time to have notice of a hearing in December and provide the necessary information to the tax collector and the property appraiser by the January 1st deadline. Finally, as I noted in my memo, and certainly an issue that came up as we were discussing this item before the Board of County Commissioners, I know there was kind of a fear of the county becoming this super aggressive HOA. And I think there are 2 protections of that. First off, one, the Board of County Commissioners specifically directed me that when you're drafting this ordinance, we want to see a supermajority requirement for any property to have to go through this. So there's not going to be a 3-2 vote or a narrow vote on any type of item. You're going to need to see at least a 4-1 or a 5-0 in order for this type of process to move forward. Second, what's very important is that in our code still today, under 973.04 subsection 4, it specifically states that the primary method is still through your traditional code enforcement process. So still the primary method of enforcing our zoning code and our building code would still be the process through which we would, give a warning citation to somebody and then issue a paying citation, have them then come to the code enforcement board for any types of fines to be levied. But the concept of this was simply give us another tool in the toolbox to use in the event we need to. And with that, I turn it back over to the commission for any questions you may have.
Thank you. I was very interested in the preamble to this where it talked about Polk County. It was an interesting preamble because in here it says the types of nuisances abated include the open storage of junk or debris, organic debris of an excess of 6 cubic yards, overgrown grass and or weeds, storage of distressed or abandoned vehicles, and unsecured pools. This is a county that has 370,000 people compared to ours, which is just under 100,000. But it goes on to say that Polk's nuisance abatement roll for 2014-15 will include roughly 440 properties. And that struck me as a alarmingly high number. That was my first thing. And I did understand as I read over this thing that it struck me that perhaps the county commissioners had some misgivings about expanding the power of the government in this way, because obviously this is a very strong remedy, for you find someone and then you say, if you don't pay it, we're going to take your property away. I mean, that's what the compulsion is here. Whereas before, we're just going to put a lien on your property, and maybe we're going to collect it, maybe we won't. Maybe we're like any other creditor, and if it's foreclosed upon, we lose out to the bank. Here, the police power is, if you don't pay it, we're going to take your property away. I agree, you're going to have a lot more compliance under that, but that's a meaningful expansion of government power, it seems to me. And I guess the question, when I think about all this, I guess the question is the problem so large of uncollected fines? Is it such a profound problem in this county? Is it such a consequential problem in terms of the finances that we are going to hand over forever and all time the power to the government to be able to take your property if you haven't mowed your grass to their liking? Because it seems to me the process goes something like this, and I'm sure I'm going to leave out several steps. A government official is going to show up on your property. They're going to say your grass is too high, or it could be something more serious. It could be something like your building's falling down and it's a life and safety issue. But that's up to somebody's discretion. Some government official is going to have the discretion to go and say that they don't like something about your property. They're going to show up. They're going to issue you a citation. You're going to have 10 days, a remarkably short cure period, I think, to either appeal or to pay the fine. Then then they're going to go up a second time, and they're going to issue you, I guess at that point they issue you the fine. And that gets added. What happens then? I mean, it seems like it very quickly ramps up to the point where let me cut through all this. I'm uncomfortable with the idea that the government should have the power to take your property except for under the most serious set of conditions. And I'm not sure that your weeds being too high rises to that level. Can you convince me otherwise?
Well, and I understand your misgivings to the chair. And I think what's important to realize is that the nuisance abatement process already exists in our code. And what we've already stated is that, one, as I said, the primary mechanism is not going to be this method. And second, you're going to have the supermajority protection. But third, I know in our code it specifically talks about you're going to need to make a specific finding, code board, that, and I'll read it straight out of the code, that the violation presents a serious threat to the public health, safety, and welfare, or that the violation is irreparable and reversible in nature. And then you essentially have, a period of time. I don't think it was 10 days. I think it was 30 days for a compliance hearing. So I think there's a pretty high threshold that we're already stating.
But what this is ultimately about, the county already has the power to go down and tear down your building if it's a problem. This is about collecting money.
Correct.
This is about whether we have the right to collect money by threatening to take away your property altogether, or whether we're just going to be like another creditor being able to place a lien on your property. That's ultimately what it's about.
I agree with you that those are the choices we have in order to have this. I think that the concept is it's really not more of a threat of we're going to take your property. It's essentially you have taxes and assessments that you have to pay every year as a property owner, and you have responsibilities as a property owner. And if you pay the $200 by a certain by March 31st or whatever the assessment is, then there's no issue. We get paid back legitimately. We get refunded the costs that we have expended to clean up the property if it rises to such a level of it's required that we need to go out there. And still even then, it's not an immediate taking of their property. You've got a tax certificate that gets issued. You would then have to go through the process of waiting 2 years before a tax deed sale could ever occur. So you do have a lot of timeline and delay.
You have a lot of time to comply before the government takes your property.
Until we take your property.
Yeah, I understand.
So it's not like, oh my God.
But the remedy is obviously much more consequential. I mean, it's much more compulsory than a fine would be. I mean, we're not expanding the power of I want to be clear, we're not debating whether we're expanding the power of the government to enforce their codes. They can mow your grass and send you a bill. They can tear down your building if it's a life, safety, health issue. They can do all these things.
And those are already in our code.
And they're all in the code.
Yeah,
and nobody's debating the wisdom of that.
Correct.
The question here, what we're debating the wisdom of is should the government have the power to collect what they've spent enforcing their code by ultimately taking your property away from you if you don't pay that bill. That's the expansion of the government. Yes, Mr. Bowling.
Thank you, Mr. Chairman. Just for the record, Stan Bowling, County Community Development Director. And I think in weighing that very legitimate issue, the other factor to look at, and the Board of County Commissioners certainly has to look at that, is should the taxpayer pay for the cost of removing dangerous structures when the owner's been given plenty of opportunity to do it or secure it, and it rises to that level? Should everybody pay for that or not? And when we're talking about, enforcing it and forcing someone or coming up with a method to try to recoup more of the cost, also I think one factor that is part of the debate is should the taxpayer pick up whatever doesn't come out of the property owner. And just to let you all know, just as part of the discussion, I have some slides I can show you the type, at least historically, not hypothetically, but historically, what is constituted, something that needs to be demolished or a nuisance that needs to be abated, if you're interested.
It says pursuant to sections 162.09 Florida statute, no code enforcement lien may be foreclosed on real property that is a homestead. That's something that the Florida legislature put into place, I'm sure, a very long time ago. And I'm sure that their reason for doing, I would suspect, I don't know, this is speculation, but I would suspect the reason they did that was for a very good reason. And the idea was that a man's home is his castle, and only in very extraordinary circumstances should the government or any creditor have an ability to take away a person's real property. But here, we're talking about circumventing the wisdom that was enshrined in that section of the Florida statute to collect fines related to code enforcement. And that just doesn't seem like something that rises to the level of what would have been the intent of the Florida statute in creating a homestead law in the first place.
And to the chair, and I appreciate your concerns and your caution about this. I know Mr. Bowling was gracious enough to state that he had some photos, and I thought they were really indicative of the types of things that had been addressed either through nuisance abatement in the past or through demolitions in the past. And Stan, do you have the ability to put that up on?
Before we get to that,
Okay.
If we had to make a guess, I mean, since we're going to talk about what the cost might be to taxpayers, since we're going to weigh the cost potentially to taxpayers versus the cost of this expansion of government, what is the cost to taxpayers? What has it been to absorb the cost of fines that aren't paid through the process we've had for collecting them over all these many, many years?
Sure.
How big of a problem is
Stan,
this?
do you want to? You've got the memo. Okay.
Sure, yeah. Attachment number 2 to your report is a memo that gives the information on condemnations from 2009 to the present that $173,490.15 has been paid to contractors, and the county's recovered approximately 16% of that, or $28,294.55. So, roughly $145,000 since 2009 has been basically picked up by the taxpayer for demolishing
$50,000 a
those
year.
structures.
It's $50,000.
Right, and then for abatement, the nuisance abatements are historically been much less frequent. We've only had 2 cases since 2009, both of them being in 2009. Again, this is in your backup. The large majority, great majority of code enforcement cases don't rise to the level of abatement.
So it's about so let me understand this. What is being proposed is that we give our county government and future county governments the power to take private property to solve a problem that is $50,000 a year. I mean, I don't mean to poo-poo $50,000, that's real money, but I mean, this seems to me to be contrary to what Florida statute seems to intend, and I would say it's vaguely contrary to my general understanding of the form of government we have, which is one of prescribed limits and prescribed powers and limits. And so you can understand my skepticism about granting this power, except for in recommending to the county commission that they grant this power, except for in, the most extreme circumstances, like we really need to have this power for a very legitimate thing that has tremendous consequences if we don't do it, because this is a big power.
Sure. Let's look at some of those circumstances on the slides here. These are the last three structures that were condemned by the building official, and the Board of County Commissioners approved demolition of them. And these particular ones that I'm showing are in residential neighborhoods, and the typical kinds of problems of them being unsecured, open, and so these are the kinds of cases that we have, and you can see that they're posted, lots of notices given, and the opportunities given to property owners to demolish them. To tell you the truth, I think in some cases the property owner doesn't have the means to demolish them, nobody's living in them or have been living in them for a while. So this is just an example that these are the last three demolitions that went to the Board of County Commissioners. It was either last month or the month before last. And this is one of two, and I'll show you an example of the other type of nuisance, nothing related to a demolition. In particular is a trash and debris nuisance, the kind of the smaller circle, the upper right one, is a situation where someone, I think they were recycling or were talking about recycling, kind of the entire backyard became this. And that was one of the extreme examples of abatement, and that's referenced in staff's attachment number 2. The other one was the golf course down the Vista Royale, Vista Gardens area. You may recall there's about 1,500 condominium units there, and the overgrown nature near those units was considered to be a hazard. So those are the examples, again, historically, not obviously hypothetically or possibility moving forward, but these are what was considered in the past to rise to the level of meeting that threshold that Dylan read a little bit earlier in the discussion.
But we already have the power to mow those grass and to remove all that stuff. The question is, we just want to make it, we want to enforce the collection of the fines for that percentage of those who don't pay it by having the threat of being able to take away the private property altogether. That's ultimately what it is.
Well, and I think Stan
I mean, we can already mow it. We can already take the trash out of the backyard. As we should. It's the government's responsibility. The power already exists, all of that stuff. The question is, are we going to expand the power of the government to be able to take your property, to force you to pay the fine?
And I think Stan articulated it well, and you articulate the counterpoint very well. I think what Mr. Bowling's point was on that trash heap that was about to fall over the fence was, is it the responsibility of the tax collector in that type of, or the taxpayer in that type of extreme circumstance to have to pay for that and essentially bear the burden of fixing that property, or is there another method or a better way to attempt to recoup our costs? And Mr. Zimmerman, to the chair, I mean, you bring great points philosophically to the issue. I just think this is another option.
When we talk about the primary method still being, I mean, ultimately, when we say to ourselves, since we're our own government here in the United States, and we say to our fellow citizens, trust us, we will be able to have the right discretion to be able to tell whom we should put this vast power towards and whom we shouldn't. I mean, I think the examples you've shown, it would be easy enough to say, well, you know, in that situation. And in that sense, it is vaguely persuasive. But right here on page 2, we see an example of the exact same power, that we're contemplating granting ourselves, that Polk County has. And if they have 440 properties, in 1 year that they've used this method with, I'd say that strikes me as not particularly persuasive. It doesn't sound to me like they're being that discriminatory in separating out the ones that really rise to the level of needing to have such a heavy hammer levied against a property owner versus ones where maybe we can use the primary method. And so I always get a little nervous when we say to people, trust us, we'll be able to discriminate the serious ones that we really need to bring the hammer against versus the ones where we can gently do it.
Dylan, question.
Sure.
As far as the Polk County 400, what types of things did they deem, or did they have the same language as far as the serious threat, irreparable, irreversible harm in their code?
Mr. Ball, that's a great question. The Polk County, a lot of their ones were actually like what Mr. Zimmerman, you would reference in terms of, a lot of weed, mowing lawns, and they'd essentially hire a company and go out there. But certainly, I think they have a broader base of list of items that they do correct. I think what staff has demonstrated in the past in terms of its aggressive nature was it was really against the egregious situations. It was against the trash heap that was about to fall over the fence, or the demolition structures that were clearly just posing a hazard of individuals who were trying to live in those structures and drug use in those structures.
But we already have, we're not, but we already have the code enforcement to do that. This adds nothing to our ability, nor does it detract anything from our ability to go out and fix those problems right now. All we're talking about is if somebody doesn't pay us, when we want to be paid, if the fine process doesn't result in payment, in the time frame that would be good, that would be the right thing for the county and taxpayers and everything else, then we're going to force compliance through the threat of the confiscation of private property. We can already collect. The question is, are we going to expand this power of government for a $50,000 a year problem? I say absolutely not. Absolutely not. That's my opinion.
Follow-up question, Dylan. As far as City of Palm Bay, what they tried to do in code enforcement cases with the many foreclosures that they had, they tried to have their code enforcement liens rise to the level of a super lien, a tax lien that would not be washed out in a foreclosure proceeding. Are you worried that this is just an end run around our code enforcement proceedings that would kind of violate the spirit of the City of Palm Bay decision? And, are we relying, what about St. Lucie and Palm Beach County? Were their numbers similar to ours, or similar to Polk County, 400?
At this stage of the research, what I was able to do was talk with one of the county attorneys in Polk County, and he was we walked through the history of it, and we went through on the tax rolls. The 2012 adoption of it was so soon, I hadn't had a chance by the time when I started to get one of the assessment rolls. I had actually been able to obtain 2013, 2014, 2015, assessment rolls are proposed. So I was able to do a little bit more research. Clearly not designed to be an end run around what the Supreme Court addressed in the Palm Beach or in the City of Palm Bay issue. This was merely just another assessment or ability of us to collect back. And the Chair, you raise a great point about your concerns and your political philosophy about the issue. For the county, or at least why the board was proposing this or considering is simply just a different way or another means by which we might be able to do a better job of collecting on the assessments that we had essentially, or the costs that the county had incurred in trying to correct some of the issues that you saw examples of tonight.
Help me to understand how what the proposed statute that we're talking about would square with what seems to be the plain intent, to me anyway, of Section 16209 of the Florida statute, which says no code enforcement lien may be foreclosed on real property that is homesteaded.
Well, I think an important difference in this is that when you have a code enforcement lien, you're going to have a code enforcement fine. You traditionally, and certainly Mr. DuBois could explain this better than I could in terms of how we've operated the process here for many years. But you have a fine, you have that rolls over, it racks up $100 a day, or it runs up to $2,000, $3,000, $5,000, whatever it is. These examples are with an assessment, is you're really limited to the true actual costs of performing whatever needed to be performed. So essentially, if it costs the county $200 to fix the problem, then that's $200 the property owner should have been paying to fix the problem. It's not going to be $200 plus the $100 fine that racks up every day. It's going to be limited solely to your assessment and your administrative costs.
And that's an important distinction. But what I'm really trying to get to is to the meaning of what Section 16209 means, and the intent of it, which was that no code, I mean, clearly the Florida legislature, I think, would have meant just what the words say, that no code enforcement lien, we're talking about charges related to code enforcement
Right.
that we're levying against a real property owner, may be foreclosed on real property that is homesteaded. And we're talking about the opposite. We're talking about making code enforcement fines foreclosable ultimately by making them taxes on real property that is homesteaded.
And what I'd like to, again, to clarify to the chair and to the whole commission as a difference is when you talk about fines, and you've used the term fine several times, and I know that seems synonymous to this issue, but it's clearly designed to merely recoup just the costs that were incurred by the county. So we're not going to use this as punitive. And I think the concept in the fines is a nature of a punitive action against the property owner. So we're certainly never going to foreclose on a property owner because of something punitive like a fine or that's racking up. What we're merely stating is
that's a fine distinction, though, because we're including the cost of the code enforcement officer's site visit, the bill from the vendor. Now we're wrapping up the unpaid tax bills are racking up penalties, 3%. I mean, that may be a distinction without a difference to someone who's receiving this. I mean,
and to the chair and to the full commission, clearly I understand your political and
there's an advertising fee that's added,
yeah, and I understand the philosophy of this. This was merely designed to be a measure that would be an opportunity to be used. I understand your concerns, and I think the board essentially directed me when I drafted this. They said, Mr. Reingold, we clearly want to see a supermajority in here, and that was the goal of the board, to try to address the issues that you've raised tonight.
Thank you.
So could you do an example for us? Given the example, somebody has a mountain of aluminum in their backyard. That is a danger to the people living in that house and the danger to the neighbors. So the county comes in, cleans it up. Could you outline the best case scenario of how that would eventually be resolved and the worst case scenario?
In terms of best case and worst case, I'm trying to understand best case, worst case for the county, for the individual, for the timeline.
For the homeowner.
Okay. For the homeowner, they're clearly given a notice and an opportunity to be heard before the code board. They're given...
Excuse me, Dylan, do you want to use the timeline?
Oh, yeah, actually, Mr. Bowling, in his slide presentation actually has a little bit of a couple timelines. First off is a timeline of how the assessment process would run, and then the second timeline is kind of the tax deed application process timeline. That ended up being a lot smaller than I wanted. But essentially, as we talked about at the beginning in terms of the amendment concept, is that by October 1st, and I'll use right now as an example. So October 1st of last year, the code enforcement staff would have brought to the code enforcement board a list of properties that they recommended to be used through this process. You would have brought it for those that were delinquent. So we could even take it before then. So somebody, let's say in June last year, had that huge mound. So your example. So June last year, huge mound of trash is sitting there. So now what happens by October of last year, they would have, then June, they would have had a hearing, notice to appear. They would have been, the code enforcement board would have ruled, yes, county staff, you need to go out there, fixed it up, let's say in July, early August, 45 days, September, now October, they come to the board and they say, board, we've done this, they haven't paid us, it's delinquent, and now we want to use this process. We start running ads in November, have a hearing in December, to determine this property should be one of the items on the roll. We mail that to the property appraiser and the tax collector. Then by June, the tax collector sends, and the property appraiser send back the list for us to fill in the number. So now you're getting into already a year after we told them this was a problem, and we still haven't done anything to the person yet other than, the process is still running. So then you go to June, we fill out the number by September 15th, we send it back to the tax collector and the property appraiser. They put it on the tax roll. You can start paying that off in November of, now we're November, almost a year, 4 or 5 months later, and that's when I can start paying it off. I don't actually have that due until March, the next year. So we're talking almost 2 years have gone by before I had actually pay off my assessment or even go this way. And during that whole time, that property owner always had the ability to go, hey, I'm going to pay off that lien on my property before you start going to the tax roll process. And therefore, they've got a very long period of time in order to address that. Additionally, let's assume that this property, to collect this was $600, $700, maybe $1,000. What I put in this ordinance was the ability for the county to break it up so that we don't punish a property owner too much at one time. So let's say their assessment, the cost of the staff to go out there was $1,000, where obviously that could be a huge uptick in what they were expecting to pay in their taxes and assessment, which is why I put in the ordinance a provision that if it's over $500, you can break it out over years, give that property owner kind of an ability to pay it out over time so that they don't hit with one big, huge increase on their tax roll. So even then, come April 1st, they don't pay it, then you then have, the tax, you've got 2 months, the tax collector in late May sells a tax certificate to somebody pays it off or buys it. You then at that point still have 2 years after that before that tax certificate holder, and if no one buys it, the county, if it's at certain levels, then seeks the tax deed application. So now on top of the process that we talked about that was almost 2 years, we have another 2-year process built into it before it even goes to tax deed sale. And what the property appraiser and tax collector have explained is it takes at least a year to kind of go through that. So now we're talking 5 years. So in terms of your question as to tell me the worst case scenario for this person, you're talking at least in that scenario 5 years before you're going to tax deed application, sale, and complete.
Then what happens then?
Well, and then it goes to tax deed sale, and yes, they could lose the property through that. And if no one buys it, then it ends up on the list of lands available, and that sits there for 3 years potentially. At any time, anyone could essentially pay off those. And then at that point, then the property would escheat to the county if no one pays it off. And then that essentially wipes out all the taxes and assessments. And the tax collectors told me that process can take up to 10 or 11 years.
If I may add something, I'm Roland DeBlois, Chief of County Environmental Planning and Code Enforcement. What Dylan just explained is the timeline that starts after the abatement has occurred and the assessment has been determined. Before you get to that point, the process for code enforcement is staff responds to a complaint, they document the violation, they give the respondent a period of time to comply. If they do not comply, it goes to the Code Enforcement Board for a hearing. There's an evidentiary hearing before the Code Board to determine that there is in fact a violation, at which time the Code Board gives the respondent a period of time, usually in increments of 30 days, to comply. If they don't comply after that period of time, it comes back to the board, and then the board makes a determination, if it's still there, whether or not it rises to the level of a serious threat to public health, safety, and welfare. And if it does, then they'll direct staff to bring it to the county commission to authorize county abatement of that nuisance. And at that point, there's still a period of time between that direction for the respondent to clean it up. If they don't ultimately clean it up, that would be when the county would proceed to abate the nuisance. So there is actually a period of time and process before you even get to the point of the assessment that gives a respondent ample time to make a determination whether they're going to comply.
But we're not planning, none of this changes any of that. This is
Right.
all under the current thing. We can do all this. None of what we're talking about today has to do with altering that.
Correct.
That should stay exactly the same.
That is correct. The pre-assessment process would remain the same under this proposal.
And the power of the county to make a decision to go in and do the abatement stays the same.
Yes.
And then for them to calculate whatever costs and fees and whatever things, that's the same. What we're talking about here is whether the county has the ultimate power to compel the property owner to pay what they say they owe through the threat of eventual confiscation of the property. I don't, maybe that's the wrong word. That's probably too strong a word. Selling it on the courthouse steps and you're gone. You know, I mean, right now they do not have the power to do that. They have the power to issue, to issue you fines for noncompliance, to eventually to abate it, to send you the bill for abatement, to put a lien on your property so that if your property were to ever sell, after the mortgage was paid off, then they can, that they would be then perhaps the next lien holder if there aren't other creditors in front of them. There's other things like that. They want to be, in essence, a super creditor, a supercreditor, not only do you owe us this, but we can compel you to pay with the threat of taking your property through a tax deed foreclosure sale. That's the only difference. We are not talking, everything that Roland has said is, it seems to me, a logical and a well-functioning process for taking care of things in the county that are, public health, safety, code violations, and no one's talking about changing that. The question is does the government have the power to force you ultimately to pay the fee through the threat of a tax deed sale, as opposed to what they currently have? And it seems to me that Florida statute says that no code enforcement lien may be foreclosed on real property that is homesteaded. I assume there was a reason they wanted that to be the case, and we're talking about kind of doing an end around on that. I mean, I know there's a difference between code enforcement lien, and whether they're fines versus we're sending you a bill for the guy coming to mow. Okay, but
Mr. Chairman, if I could, we do have that power. The county does currently have the power to go ahead and foreclose a code enforcement lien on anything except homestead. So the second house, I think that was shown there, the dilapidated structure on it, once we go ahead and initiate code enforcement proceedings, we could go ahead and once the code enforcement proceedings have ceased, we have to wait 90 days and then we can go ahead and start foreclosure. There was a commercial property down on US 1. I think it was one of the old car dealerships that went to demolition. It's commercially zoned, certainly not anybody's homestead. We could go ahead and foreclose our lien by
but not on homesteaded property. So what we're talking about now,
that's correct.
So now what we're talking about is really just extending the power to homesteaded properties. Is that correct?
We are extending the power to collect against a homesteaded property. Now,
through the threat of foreclosure. And
no,
tax.
there's really no threat of foreclosure or anything like that. It's no more threat than you have currently existing as far as your taxes. You don't want to pay your taxes? This is what's going to happen to you. You don't want to pay the extra assessment that's been assessed to you, just like paving and drainage, just like sewer water assessments that could be assessed against you. You run the same risk as you do. We've just now added code enforcement as far as in that rare situation where there might be a serious threat, irreversible in nature. Roland, the one question that I had for you is, what was the serious threat to health in the Vista Gardens, Vista Royale situation?
It was the scale of the potential threat during particularly drought season for fire in close proximity to multiple and large number of condominium units. That was the justification beyond, say, a single-family lot with an overgrown grass within a subdivision. That was the justification for the threshold.
Have we ever gone and mowed somebody's property under the nuisance abatement in a single-family residential setting?
No.
Okay.
The only, typically where you've seen it happen is associated with an abandoned structure. You're looking at the overall property, and that's where the cleanup is kind of associated with a condemnation demolition. But other than that, no.
Just trying to think, if there would be a residential situation, say a swimming pool that needed to be secured, what is the administrative cost in securing that? Aside from the cost of securing the pool, what administrative costs would be involved? Can you give us a ballpark estimate on something like that?
It would be whatever they said it is.
Well, I think when we did the most recent matter before the Board of County Commissioners with the lien that was on the abandoned house that was in foreclosure, you had a matrix, I believe,
typically
that you used.
for a case that goes through a code enforcement process and ultimately it results in fines due to lack of compliance, the administrative cost is typically around $1,700 to $2,000. If there was, but again, this is not for fines, this is for costs for abatement. If you had a situation for like a pool, or depending on the level of abatement, if it's just going to be to secure the pool versus cleaning it or emptying it and securing it or covering it, you know, we'd still be talking a matter of probably a couple to a few $1,000s would be the ultimate. That's my estimate.
So in theory, in that situation, is it possible that once the county goes in and secures the pool, cleans it, drains it, whatever, in theory, is it possible that that property could end up in foreclosure because of the failure to pay that $2,000?
If it's not a homestead under the 162, there's the opportunity, as Bill had indicated, to foreclose if that was the county's will to do that.
But I think your question is, if we have an exposed pool and the assessment is $3,000 and it's not paid, could the bank then say, I'm sorry, you're in default in your mortgage because you haven't kept up with the assessments, therefore we're going to foreclose on your property?
No, I was.
But currently, what would happen without this proposed amendment is it would be recorded as a lien against any real personal property against the property and any other real or personal property of the respondent. And it would sit there as a lien to cloud the title, essentially, until paid.
Currently, the remedy for non-payment is a lien on your property, like any other creditor that would place a lien against your property. What's proposed is that the remedy would be that they would put the debt against your tax bill. The reason they would do that is because that's the ultimate compulsion, because if you don't do it, eventually you lose your property.
Right, and that's my question.
Yeah, ultimately you lose your property.
Yeah.
I guess the other question that I'd have following up, and I don't know if any other jurisdictions have run into this problem. I have a mortgage on my property. I have an unsecured pool for one reason or another, whatever it might be. There's a $3,000 levy against it. Now, your bank is the one that pays your taxes, and you just pay that little extra a month escrowed so that the bank can pay your taxes for you and make sure that they get paid so their collateral isn't in jeopardy. Well, now there's an extra $3,000 that's been added to your annual escrow amount that the bank would be faced paying.
Well, I think under this ordinance, because of the cap on how much would be added per, you know, if it's over 500, you could decrease it. I think the concept is that you wouldn't see this extra 1,000, 2,000, 3,000 show up. I think the concept would be that all of a sudden, you know, there'd be a new $300 or $200.
But understand this.
And
here's my thing about that. All of those things, and the way it's currently drafted, they seem reasonable, and all the people sitting in this room are reasonable. We could probably all sift through 100 of these and come up with a just, result in most of them. I trust everyone sitting in this room, but this is an expansion of a profound government power that, once the power has been expanded, what the fees are, what the grace periods are, all those things can change anytime. Once the cat's out of the bag on it, what they decide the administrative fee is going to be, what they decide the grace period is going to be, all of those things can be changed with the stroke of a pen. You understand?
Can I ask one question? Did you say a minute ago that you could also levy against personal property for a code violation? Did you say that?
Yes, under Florida Statute 162, a lien recorded in the public records against
So
any
we could
real,
take their
any
car
real or
and we wouldn't
personal
have this
property.
problem?
Technically, yeah, it could be lien against a car.
And to the chair, you've made great points about your concerns about, just the general role of government and what the role of government, and the place it should play in our society. I think that's why the board directed me to make sure that we included some additional, restrictions. If there are any additional ones you think, that might be helpful, we certainly could consider those. And certainly there's no ability to, not convince you, but at least I understand your viewpoint. You've made it very clear.
Well, I would turn that around and say this to you. I would say the very fact that the county commission seems to want to have so many safeguards in there reveals their own misgivings about this, and probably their own concerns similar to the ones I have. And I would only say this. I would say I don't have any absolute lines in the sand about, you know, agreeing to grant this extension of, you know, pretty profound government power. But it seems to me we would only really contemplate doing this to remedy a profound problem. And I don't think we are faced with a profound problem here where it's so big that we have to say, all right, we have to give government a lot more power to fix this for us as taxpayers, as neighbors, or whatever else. I mean, the code compliance system works well. We still have the right to go in and abate the property and everything else. Do we want to give such a power of collection that ultimately could result in the government taking over the power for a $50,000 a year problem? No. No way. It's just not that big of a problem that we want to, that the remedy is vastly out of proportion with the problem, in my estimation. That's my opinion. I think I've said my piece. I'm not going to say anything more. Thank you for listening to me.
Mr. Chairman, just a reminder, it is a public hearing. I'm
Thank
not
you.
sure that we have a lot of people out there, but
Would you
It
like to
does need to
speak this
be
evening
said.
on this issue? No. Public hearing is open. Anyone wish to speak? Public hearing is closed. I think it's an issue that's worth further discussion. If anybody has anything more that they'd like to say about it, I thank you for indulging my own thoughts on it.
I guess we look at this and they're looking at the extreme instances where they really feel they need to have to go after a particular property. Maybe this needs to be rewarded or reworded just to that fashion, so you just can't go after any simple little $1,000 or $2,000 fine and take people's property. Maybe it needs to be set up for some more extreme instances, and maybe you can go back through and make a definition of what you consider public nuisances and something that's, you know, a threat to the health, safety, and welfare of the general public, and maybe dissect that and have two different standards. That might be a better way to go instead of having this broad power and define it better.
Well, let me see if I can answer that. They already have the power to do what they want to do, whether, you know, based on that standard. This is just about their remedy for people who don't want to pay or
Correct.
are unwilling to pay.
I understand that.
If they don't pay their taxes, they lose their property. If they get too many code violations, they can lose their car. So now you're just saying, over a 10-year period, can we take a piece of property that's going to fall over and destroy the one next to it? I don't see the problem. They've had many chances to regulate it, to fix it, to do something about it, and chose to do nothing. If the time period was 2 weeks, I'm with you. But when he showed it was almost how many years before you actually do anything? I mean, why don't we give them another 80 warnings?
Well, another thought is that, you know, if property is sold as a tax deed, it's not necessarily given to the county. It could be placed in the hands of a more appropriate property owner that would make use of that, you know, now vacant lot after a building's been demolished. That's just another thought.
We just want, I mean, like like it says in here, the homestead is protected by the state, put it in to protect homesteading. Now we're giving it the option to take that away.
Homestead isn't protected if you don't pay your mortgage. It's not protected if you don't pay your taxes. It's not protected if you don't pay your code violations. It's not protected many times.
It is protected against code
The lien
violations.
is there, and then the lien is wiped out by the bank if the bank happens to have it, and the taxpayers pick up the shortfall for the property owner who didn't do anything for the 8 years they've had the fine.
The government currently does not have the power to take away your property if you do not pay your fine for code violations.
They do if you don't pay your taxes, though, right?
Yes.
Okay.
And what we're saying is, are we going to give the government the power to take away your property for not paying your code violations?
Well, I think we differ.
Yeah, I respect that. That's fine. I just want to make sure we're clear on the terms of the debate.
Yep.
I'm not sure the term taking is the best term as far as, I'm thinking a taking would be in an eminent domain type of situation where the government goes in and takes possession of the property, period, through its power of eminent domain. Here we have a situation where essentially the property owner loses their property. It's not taken from them. They have lost it.
I wonder how many people are in that situation that actually pay their taxes as well.
You know, in the demolition cases, I can tell you that the majority of them, after the $4,000 lien for the demolition of the property attaches, they stop paying the taxes because they realize that their 50, 60-foot wide lot is basically, that it's completely upside down because of the demolition lien. And so they walk away from it, don't pay any more taxes, and sooner or later it escheats back to the county because nobody's going to buy the property knowing that there's a $4,000 lien on the property. So essentially, you know, that problem isn't going to be solved by this situation. Now, the code
Like I
enforcement
said, it's a mighty
actions-
powerful remedy for a remarkably small problem. But is there any more discussion on this issue? Any more thoughts, any more comments? Staff, anybody? I guess I'd ask for a motion then. Motion either to
approve, deny, or recommend additions, deletions.
And if it were the will of the board, I would simply ask that you approve with the amendment as proposed by staff, but certainly defer to your wishes.
I approve, or I move to approve staff's recommendation.
I'll second.
Any discussion? I think, let me ask this clarification. Do you mean to approve staff's recommendation with the, is it called the amendment?
You know, being from Jacksonville, we traditionally called a change to an ordinance an amendment. I was just using my traditional language.
Would you like to amend your original?
No, and I took her motion as staff recommended, which was essentially with my amendment.
Did you get that, Maria? I mean, I'm sorry, did you get that?
Staff
recommendation plus with the change is that correct?
Yes.
I just want to, I don't
As
want
they
to put words
stated
in your
it.
mouth.
No,
just
I
wanna make
appreciate
sure.
that, as it was presented to us.
As it was presented to you. All in favor?
Mr. Chairman, I believe the motion on the floor is to move staff's recommendation, period, as it appears in the backup. Is that correct, Ms. Calderon?
Yes.
And that is your second? I'm sorry.
The clarification I was going
I
for.
second that
Okay.
motion.
Okay.
So,
Can I ask for clarification? Point of clarification. My understanding is what you requested, that it would be staff's recommendation plus the change that was laid on our desk at the beginning of this meeting. That's what you are asking us for. Is that correct?
That is correct.
Is that what you intend in your motion?
Yes.
Understand?
Is that with this? Is what
That,
you're asking?
exactly.
okay.
Exactly.
Have the amendment? All right.
Okay. So that clarification is that your amendment includes?
Yes.
Okay, thank you. And is
Thank
that
you.
what you're seconding?
Thank
Jordan?
you.
Yes.
Okay. All in favor?
Aye.
Aye.
All opposed?
Nay.
Nay. I don't know if I got that vote. Can everyone who said aye raise their hand, please? All who said 3-3.
3-3.
3-3.
That's an interesting result.
Excuse me, who's in favor?
All in favor was Maria,
Thank you.
Jordan, and Dr. Day.
If I,
Charles, Sam, and Todd were
Thank
nay.
you. Thank you.
if I may have a clarification with a 3-3 vote, to staff or to Mr. DeBrawl, does that stay in your commission? Does it move on? I'm just trying to figure out what the process has.
It still moves on to the board with that.
Okay, as a denial, correct?
Correct.
Thank you very much.
We'll report it and have
Thank you
the
for your
minutes.
time.
And I really appreciate all your comments this evening. I think this was a very constructive and healthy conversation. Thank you very much.
Thank you for your time. Very much appreciate it. Okay. Wait, we're not done yet. We are very nearly done, I promise you. Item number 5 are commissioners' matters. Does anyone have any? No. Item number 6, planning matters.
Thank you, Mr. Chairman. Just two things. One is, since your last meeting, the Board of County Commissioners approved a redesignation of a conservation area south of Oslo Road, the Diamond Orchid Tract, about 70 acres, in accordance with your recommendation. And also, there will be an April 10th meeting, your next Planning and Zoning Commission meeting. We have the West Gifford Initiative overlay regulations that will be before you all as an LDR amendment. And that's all that I had, Mr. Chairman.
That's great. Any attorneys' matters, sir?
None, Mr. Chairman.
Wonderful. We are adjourned.